entitled People of the State of California versus Sorge. Case number is 98 WF 0576 and 11 WF 0253. And if I could have appearances starting with the people.
Good morning, I'm Michael Goldberg, GLD, DPR, Mr. Zorge, here in 977 DPR.
Okay, all right. Well, good morning, council. All right. So before we start, let me just make a few disclosures. And first and foremost, there is nothing about these cases or about what I'm about to disclose that in any way, shape, or form is going to affect my ability to be fair and impartial. But I do think that council needs to be aware that before I was appointed to the bench in 2015, I was employed in the Orange County Public Defender's Office. When I left, my title was Public Defender of Orange County. I've looked at, to the extent possible, both of these files. I don't see my name associated with any of these cases, and there's nothing about that is going to affect my ability to be fair and impartial in the case. I just wanted you folks to be aware of that. So let me, before we even start, let me sort of indicate a couple of things. Mr. Williams, through no fault of your own, for whatever reason, a number of these filings that you made had not apparently been imaged. And so, consequently, I received your opposition, I think it was 2 days ago, and that was the 7-page opposition that you filed entitled People's Opposition to Defendant's Motion for Dismissal of his prior PC 186.22A and resentencing. Yesterday, I was informed either by my bailiff or clerk that you had done a subsequent filing, and took us a bit of time to be able to find it, and I didn't receive that myself personally. Not that you didn't file it, but I didn't receive it until yesterday afternoon. And that one, while the actual response itself is about 3 or 4 pages in length, it does have a number of exhibits and attachments. So I want to, and I know one of those appears to be the preliminary hearing transcript. And then there is a what appears to be a sentencing transcript from Judge Singer. And I do want everybody to know that given the length of time between the time that I received it and by the time it actually got printed, I have not had an opportunity to fully review the attachments. That is the preliminary hearing transcript. I know that Mr. Goldfeder did submit the sentencing transcript on case 11 WF 0253 some time ago, and I did review that, and I presume that's part and parcel of what you attached to your people's response to defendant's reply. But I haven't, compared them side by side. In addition, probably through inadvertence, I can pretty much tell you that on the preliminary hearing transcript, that one of the things that I am missing from the packet of materials that I received is one page of the preliminary hearing transcript. So I go from page 15 to page 17. So page 16 of the preliminary hearing transcript is missing from the packet of materials that you have submitted. I say all of that so that everybody's aware that I have not finished reading the attachment to the people's response on the case, and I'm not going to issue a ruling until I read everything. And but I am missing that one page, so you're going to need to augment or supplement your response by providing the court with a copy of page 16 of the original preliminary hearing transcript, okay?
And if I maybe heard, I too noticed when I received preliminary hearing transcript, that page, I believe it's 16, is missing, and it doesn't exist. My investigator who got the preliminary hearing transcript from the court further inquired and asked the clerk's office to send us page 16, and their response was that they could not be found. So I
Okay.
believe when that transcript was imaged 20 years ago, back in 1998, that page must, for whatever reason, been omitted, and so it no longer can be found in the court reporter. Does not have that either, so I won't be able to provide the court. And I did notice when I was reading through the transcript that it wasn't there as well.
Okay, all right. Well, I did want to tell you that I did notice that as well.
Yeah.
And Mr. Goldfeder, let me ask you this. If I remember correctly, not for purposes of the preliminary hearing on 98 WF 0576, but I think for subsequent proceedings, you were, well, no, you were not counsel for those subsequent proceedings. You don't happen to have a copy of that preliminary hearing transcript with page 16, do you by any chance?
I wasn't associated with that case, Your Honor. The only thing I have in that case is the abstract of judgment.
Okay,
That's the only thing I've obtained from that file.
okay. Well, let me, just to make 100% certain, have you received and reviewed the people's response to defendant's reply that contains the preliminary hearing transcript?
I am not, Your Honor.
Okay. Mr. Williams, did you forward a copy of this to Mr. Goldfeder?
I did, and I would like to explain to the court too. On Wednesday, late afternoon, somewhere around 4 p.m., I received an email from the clerk in this department at the time. I think it was Jose
Morales.
Morales, and he had asked me to call him. And when I called him up on Wednesday around 4 p.m., he had said that he received Mr. Goldfeder's
Morales.
Morales, I'm
Yeah.
sorry.
It's okay.
But, and then I followed up the next morning, which would have been Thursday, and I don't think Mr. Morales, I couldn't get a hold of him, and that's when I then spoke to a few other clerks, and finally I was able to get a hold of, I believe, one of the, head clerks around sometime in the afternoon, around 2 p.m. And at that point, she had just recommended that I print out my response to the defendant's response. And so then I just hand served it with the clerk at around probably 3 p.m. yesterday, which is why it didn't get to you till so late. It just was some email and electronic problems. But I believe Mr. Goldfeder received a copy of that on Wednesday evening when I had emailed it. But he's shaking his head, so I don't know.
Okay, well, first thing is this. Let me start by telling everybody that, this is not uncommon, okay? These things go back and forth, and I'm certainly not blaming anybody, okay? Let me start with that. And I can sort of indicate to you that, on Wednesday, I started, reviewing, Mr. Goldfeder's, reply to the people's opposition. Mr. Morales was my clerk on that particular date, and I noted, okay, on page 1, I read it all, but I noted it says the People's Cornerstone Showcase appellate case is People versus Griffith, prominently cited on page 5, line 4 of their opposition papers. And there's, at which point, I said, to Mr. Morales, hey, where is the people's opposition? Because you made reference in your reply. At which point, Mr. Williams, I think that's when Mr. Morales reached out to you. And I don't remember whether it was either Wednesday or Thursday or Wednesday, I can't remember the date, that then I received a copy of your opposition, okay? No fault of yours, I just didn't get imaged, but that's how it all started when I was asking for this. Subsequently, I received a copy of it, and I also made some inquiries through the clerk's office to make certain that your opposition was imaged. And initially I was told that it wasn't there, but apparently that's been cleared up, so that's been imaged. And then subsequent to that, I don't know how it came to my attention, but it came to my attention that you may have filed this response, and I didn't have a copy of it. And I know that someone reached out to you because the bailiff told me that you had actually called the court, and I think that was in the morning, yesterday, saying, I filed this subsequent document, and I realized that I didn't have a copy of it, so I made inquiry through the clerk's office to figure out whether it had been imaged or not been imaged. Apparently it had not been imaged. So one of the clerks reached out to you to make certain that I got a copy of it, and I ended up getting it, like I said, about 3 o'clock. I quickly perused at it yesterday, although I did review it, and by that I mean the actual, your written opposition, not the exhibits themselves, yesterday. And I did that this morning, although I have not completed the review of the attachments. And that's all I'm saying, okay? My concern right now is twofold, okay? I feel that I have a pretty good grasp of the issues, although there are a number of questions that I did want to ask both parties in this particular case. And part of the concern that I have is that Mr. Goldfeder have a copy of your response, which I received yesterday. And apparently Mr. Goldfeder is indicating he had not received a copy of that, okay? I haven't finished reading it, and like I said, I am the sort of person / judge that likes to read everything. I think if it's important enough to be filed, right? If the parties believe that it's important enough to be filed, then, you deserve, in particular the defendant deserves thoughtful consideration of this stuff. So we're gonna have to deal with what we're gonna do in order for what that does to today's hearing, because Mr. Goldfeder doesn't have a copy of the people's response to defendant's reply. And so that, I don't know how you folks want to handle this. I mean, the case has been extensively now briefed as far as the court is concerned, and the court has, without having read the prelim transcript or the sentencing transcript in any great detail, the court has a pretty good grasp of what the issues on the case are. And if you want, I can tell you where I think, or what it is that I want to hear, mainly from both sides on this particular issue, and we can take it from there. Do you want to hear that, or do you want to wait, Mr. Goldfeder, until you've had an opportunity to read the filing, which is about that big?
Well, since I already filed the sentencing,
Which one?
the hearing from that, with the court,
Three lift, one rusty, but they're perfect.
January 28th.
3 lift
Before
and
the
1
court
rest,
hearing
rest one?
transcript from
Okay.
the
My brother's court hearing, I'm trying to tape it. One second.
Vitality of that summary hearing transcript, since there was a plea agreement on
Come on.
charges. So regardless of what happened at the trial, I think that's kind of a foreclosed matter once we get a plea agreement, maybe charges on that. So.
Hasn't come in yet. Did you ask for this board just now?
Oh,
And regular wrestling, how many?
One classic.
One?
Yes.
Okay.
Well, let me tell you, I think, and again, you don't have the benefit of having at least read the 3 pages initially, which is, I think, people have, and I'll hear from them directly, but and this is what I'm speculating, Mr. Williams. Their position, okay, is a very nuanced legal argument, and the argument, as I read it, is, look, Valenzuela is not directly on point in this particular case. Because in Valenzuela, okay, the defendant had actually gone to trial, and the theory of robbery had been rejected by the jury. And they're relying on, which is one of the bigger issues that I want to hear from you, particularly Mr. Goldfeder, once you've had an opportunity or once we really begin this issue, is they're relying on that language in Valenzuela. Now, they're not, I think, disputing the holding of Valenzuela. Okay? They're not disputing that from what I can gather. But what they're saying is, you know, Valenzuela is distinguishable because Valenzuela, the defendant went to trial and he was acquitted of the greater charge, which was the robbery, and the jury, you know, found him guilty of the lesser, which was then subsequently made a misdemeanor pursuant to Proposition 47, and consequently the 186.22A enhancement went away. I think the argument that they're trying to convince the court is, look, the language in Valenzuela, specifically that factual language that says, quote, given the facts of this case, the reduction of defendant's theft conviction to a misdemeanor establishes that he cannot be regarded as having engaged in felonious criminal conduct. They don't take issue necessarily with that legal proposition, my understanding. But he says, because the people do not explain how defendants' underlying conduct could be regarded as felonious under a different theory, at least in a way not already rejected by the jury, parentheses, which declined to convict the defendant of robbery. I think they're saying, look, in this case, we can offer a different theory, right? And that theory is supported by the magistrate's bond over of the defendant on the robbery charge, which was dismissed pursuant to a plea agreement. And so I think that's the reason why they're proffering the preliminary hearing transcript to the court as an alternate theory of felonious conduct that would support a 186.22. Now, I haven't made a determination on any of that, but one of the issues that I did want to have addressed by you, Mr. Goldfeder, is what does the court do with the language of Valenzuela? And is Valenzuela really, or is the holding of Valenzuela